The government takes a tough approach on sexual and hurt offenses. We have made significant amendments over the years to enhance the protection for victims of sexual and hurt offenses. In 2019, we amended the Penal Code and POHA, the Protection from Harassment Act. Under the amended provisions, those who commit sexual and hurt offenses against vulnerable victims face enhanced penalties that would include victims in intimate and close relationships with the offender, children under the age of 14, domestic workers, and physically or mentally disabled victims who are substantially unable to protect themselves from abuse, neglect, or self-neglect. Offenders who commit offenses against such vulnerable victims are now liable for up to twice the maximum prescribed punishment. For example, if you take the unfortunate case of the Myanmarese foreign domestic worker, Ms. Piang, if those facts had taken place after the 1st of January 2020, then those found guilty could face much higher punishments. For example, giving another example, there was a case some years ago. A husband and wife abused their foreign domestic helper. The husband had slapped, punched, and kicked the victim, hit her with canes and bamboo sticks, and pushed her against a cabinet. The wife had slapped and punched the victim. They were convicted of numerous offenses, including voluntarily causing hurt under the Penal Code. The husband was sentenced to 43 months imprisonment. The wife was sentenced to 2 months imprisonment. If those assaults had taken place after the 1st of January 2020, their sentences are quite likely to have been higher because the penalties have been enhanced. We also specifically made criminal acts like voyeurism, dissemination of intimate images without consent. These have become more prevalent with technology. The conduct were offenses previously, but not specifically identified as a voyeurism offense or a dissemination of intimate images offense. Voyeurism, for example, previously would have been charged under insulting a person's modesty. Dissemination of intimate images, for example, would have been charged under distributing pornography. The maximum penalty for voluntarily causing hurt has been increased from 2 to 3 years imprisonment. We have also enhanced penalties under POHA for harassment of persons in an intimate relationship with the offender and for repeated breaches of protection orders. Both the Penal Code and POHA amendments took effect on the 1st of January 2020, and the amendments apply to offenses committed on or after that date. In 2018, the CPC and the Evidence Act were amended. The accused and counsel were required to seek the court's permission before questions could be asked about a victim's physical appearance, sexual behavior, where these do not relate to the charge. We also prohibited the release of identity of victims before a complaint is made, and the default position for trials as closed-door hearings when the victim testifies. We also allowed the use of physical screens to shield victims from seeing the accused when testifying in court. Earlier in 2012, the Evidence Act was amended to remove provisions based on outmoded assumptions about victims of sexual offenses. And when it comes to sentencing of adult offenders who commit sexual and hurt offenses, our position is that the sentences must reflect that such acts are deeply offensive to our fundamental values. Outrage or modesty is not merely an offense that a man commits because he is tempted by the way a lady dresses. Voyeurism is not merely a thoughtless act that a young student commits in a moment of folly. These and other similar offenses, whether committed against a female or male victim, should be dealt with seriously. These actions must be seen as an affront to our fundamental values. There can in general be no excuses for these offenses. Mitigation pleas based on the offender's educational qualifications or academic potential should not carry much weight. For such offenses, principles of proportionate punishment and deterrence should generally take precedence over rehabilitation. This means If you touch a woman inappropriately without her consent, if you upload intimate images of an ex-girlfriend or any other woman, if you video record a woman showering, you must face serious consequences in law. And you shouldn't be able to come to court and say, you have a bright future, you will go far, and so on. You can go far, but first serve the sentence. If we make examples of some offenders, however bright their potential outlook in life, then the message of deterrence will likely be stronger.